Hey y'all, and we back. Um, Hope everybody doing okay. We back on our journey with Bryan Kohberger. Not quite yet, but the evidence of Bryan Kohberger DNA hearing continues. Uh, what's going on, y'all? Is the Kohberger attorney are trying to get is asking the judge to dismiss most of the evidence in the case, okay, which they believe relies on a genetic investigation process. And Bryan Kohberger, attorney, think that is unconstitutional. Okay, also, Kohberger defense team also argues that the search warrants in the case were tainted by police misconduct. So we right here. This has been like a 2 day hearing, and that started Thursday, and then what started Thursday, and so that's where we are. So what we're gonna do is tune over to the hearing. Kind of prosecutor said that the investigations, including the use of genetic and genealogy, are properly done. Everything that they said was done. That's defense doesn't think they did it right, and I wish kind of like on the defense side a little. So what we're gonna go ahead and get started with Cole Burger DNA hearing, okay? And they did it kind of sneaky this time with this hearing. It was held behind closed doors when the judge said it's meant to avoid potential juror being tainted by hearing evidence that might be allowed in the trial. They don't want the jury here. All of that was what they may use. And let's go, y'all. Let's tune in. Y'all don't forget to like, share, and subscribe, people. We got to get our lights up. Okay.
Your Honor, our position is that the court should suppress the IgG identification and everything that flows from that. This is supported by the Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IgG work, investigative genetic genealogy. And we think every single one of those stages a warrant was required, none was given, and so this must be suppressed. Your Honor, I'd like to identify the three stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample off from laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All three of those stages of this case, there should have been a warrant, and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, If society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the
That's
reason
right.
for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at, that have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody, is more than twice as big when it gets to the FBI from Othram. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Your Honor, I don't have the jed.com file. I don't have.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to, because as the state has posited, it wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger.
Yeah, I'm sorry. This is so funny. Answer the question. You haven't answered the question. I'm not on Bryan's side. I'm just on the real side. Answer the question. What do you think that they secretly took his DNA and put it in a machine or did something and say that he did it? Or do you think that they saying that his kin people, somebody down the line did it? Answer the question. Don't be afraid of the judge.
I was on the night.
No, I'm not talking about the DNA. I'm talking about what they tried to match it to.
What are you talking about, Judge? But one thing that they said his DNA was on the night sheet. Now, what are you talking about, Judge? Where else? They have no other thing else to go by but that knife sheet. Girl, don't be scared of him. Talk.
this way. The way that those databases work is looking for shared DNA. But those databases don't turn out a name and say this is
I have
our
a privacy
suspect.
interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA. If
Not necessarily in, let's say, my DNA.
Now, I understand the judge as well because I found out that it's a situation happened like that. We'll talk about that at the end with the DNA, and I knew who my brother was, but everybody else thought that they got everything wrong, but they was right about the DNA through them the system like that, the ancestors. Though it is truth behind it. So we'll talk about that at the end.
What privacy interest do I have in the search of the DNA of others?
that's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position.
That part is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in violation of his rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here he went to the crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law, and I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory, and I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from, example, latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS.
I understand what she's saying. I understand what the defense attorney is saying in this situation. You know what I mean? So this situation is different from ancestors, but this is how they found out about Bryan Kohberger DNA is through ancestors. I don't believe that. I just don't. I don't know. I just don't believe that. I think that it's something the FBI did a lot of little something. It was a lot of tricks going on in this situation right here with the DNA. So I think she's doing a good job.
This is a different
So I'm going now to, the constitutionality of using the DNA that was allegedly on the knife sheet. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea. That somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I think one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, case when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about. Our first point is it was an illegal search, and this is if
Search? Which search?
Assumption.
Which search? It was illegal.
First the snip at Othram, then the snip at the FBI, and then the trash pool.
You're talking about the DNA testing of the material left allegedly on the knife sheet.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department.
She right.
At the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS. Uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret that happen when there's a portion of the DNA taken and it's searched by Othram to create a snip. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the snip ourselves. That's what I'm talking about. Those are the problems. As far as asserting family
specific DNA tests of the sample that goes from legitimate to illegitimate.
Yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath.
My theory is, I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose, and I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is Kohberger. I'm sorry?
Can you give me the site to the Davis case?
2 seconds. 2 seconds and glasses.
Anyone with $10,000 or more in credit card
This is interesting. I heard y'all about a commercial.
I apologize, because my memory tends to be fact-based and not name-based, so that's my liability.
Oh, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our. It is 690 F 3rd 226. All right, and so those are the three areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has in another exhibit.
That's not a constitutional violation.
Your Honor, it goes to privacy.
Suppressed for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IGG databases that changed their rules in terms of use after a different case used IGG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
I don't think that that's the way the question should be looked at. The question should be looked at in the way that we always look at warrantless searches.
Ooh.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have the burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification.
That's what she doing, Judge. And you keep booming her. That's what she doing. She's telling you. She's telling you. There was no warrants, no justification, no policy here. No privacy here. This is what she trying to tell you now. Y'all left them with nothing. Y'all they did nothing but clear that house out. Clean that. Y'all cleared that house up so good. Yes, y'all did. That's what she trying to tell you. And by you being the judge and you think that you the judge, whew, I'm gonna let you go. I'm gonna finish.
For this search.
Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law, Carpenter, thinking about cell phones. That's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required.
You do supposed to have a warrant, Judge. Y'all didn't have nothing yet. None of that. Y'all just point finger off that little tiny bitty little DNA that y'all sniff and no telling how much where y'all got that that little bitty tiny little DNA from to put on that knife. Y'all could have got the daddy DNA some kind of way and put it on that knife. We don't know. That's the only thing that you all have. Come on, you got to have more evidence in this. This just ain't right here. This ain't right. And I'm gonna stick with my knowledge of what I've been listening to. Not only the defense on both sides. I don't understand how they did this. How they got this man locked up for 2 years just for a little tiny DNA and all of that DNA in that house. And the only thing y'all gonna do, and then what she said that it was secretly done. That's what she trying to say. No warrants, no policy. It was secretly done. Privacy. That's what she said. And it was done privately. Because y'all know that y'all got to have somebody that did this. So y'all point the finger at Bryan Kohberger. I'm gonna stick with what I said. I want to see how they're gonna do this. Really. So Judge going back and forth with her, you know.
A warrant was required for these subsequent searches, and there was no warrant in this case. There's an expectation of privacy.
I struggle with, well, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Okay, now what you got to do, defense? Listen to what he's saying. He's trying to tell you, you are going to have to convince him that you telling me that Bryan Kohberger DNA was on that knife sheet. Talk. You're gonna have to. He just said. Only thing he said was convince him that that wasn't Kohberger DNA on the knife, on that knife sheet. Convince him. That's all the thing he wants you to do. Convince him. Don't back up now, baby. You're doing good. Come on now. We need you to talk. Got to talk now. Just convince the judge.
Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Thank you. And I agree with her. In no way in the world that the person who did this, no DNA on his shoe, no DNA. What he did, walking there with plastic bags up on his feet. Because after all of that DNA, somebody clothes messed up, somebody rubbed against that wall, somebody smeared against the rail, somebody did something with the carpet. They took everything secretly out their house. All the DNA that what they did, since that was a college area, college house, they took everything out of there. Every little piece and everything. And then what they did was smart was tore the house down because DNA was all in the house, y'all. DNA was all in the house. I'd never seen nothing like this before. And prosecutors know this wrong. Judge know it's wrong. But judge got to protect that. He protecting that college credentials. But I think they lost some for some reason. But here we go. But she is right. It's no way. It's no way. All through the house, there was no DNA left in the house. Just a little tiny DNA on a nice sheet. Man, y'all got that DNA from his daddy. And then y'all say, okay, Bryan did that. Whew, Jesus.
Go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive. The court here in that case was about it was about third party with cell towers, and there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell,
come on, Judge. I'm gonna tell y'all. This was set up like I thought it's supposed to be set up. But they want Bryan Kohberger as the person be convicted of something that they ain't even got enough evidence on. They don't. But evidence is the house that they tore down. The house is the evidence, y'all. The house was torn down because evidence was throughout the house from the floor on up. So since they couldn't get rid of the evidence, they got rid of the what? The house. The house is the evidence. But she got to push it and talk. She got to push this thing. If she don't push this thing, Bryan Kohberger will be locked up forever. And it go back to what she said about the DNA. No wants, no policy, secrecies, DNA privacy, everything was private. No warrants, nothing. It just saying towers. I don't even see no probable cause here. I don't even understand how they got probable cause behind Kohberger, Bryan Kohberger uh, case. I don't, y'all. I don't. I really don't. I want to see how they're gonna do this. I really don't.
cell phone and it uses the towers, there can be a trail of where you went. I'm sorry?
Do we leave fingerprints everywhere?
Do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you go.
Wait a minute now. You messing up, man. You messing up. You messing up. You got to do better than this, defense attorney. You have to do better than this because they can use their cell phone. They can use the towers. So you got to push this a little harder than this. Let's get back on the DNA. They can do that now. They don't have to have Bryan Kohberger permission just to use his phone. No, the warrant. He don't have to have no kind of warrant to get his phone and go through his phone. No, if they figure that they got evidence that he was involved, they can use his phone. So you're gonna have to do a little better than that. Regardless if his phone is for his business or not.
Or to go to the doctor, your cell phone sitting on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches, and that's what we're asserting here.
He don't know what to say. He don't know what to say, but all right.
And you can't stop shutting that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left. If that's going to be the standard, you put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into two databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the three places there was a warrant required that wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where people consented to have their DNA searched, our case is different. The FBI went into two other databases and searched those. There was nothing else happening until that happened.
But they do have now the defense lawyer. They can't do your DNA other ways besides the old-fashioned way that you're talking about. They got new methods, doing DNA, updated information of doing DNA. So they do have that. So I don't know where we're going right here. I really don't.
And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we're learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's.
But they did keep a lot of stuff secretive. It was a lot of things secretive from what the when the prosecutor got to give them something, but the prosecution team was keeping a lot of things back from the defense. I don't understand this right here. They got to do better than this. I really don't. I don't think they did the defense team right. I really don't, y'all.
Secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy.
I see what she's saying. Because it was the way they doing the judge. You ain't saying nothing because you know she telling the truth. I believe her. There's so much secrecy in here. Secrecy because a violation of privacy, his privacy. They know it wasn't. They wasn't right about that. I'm with her now. I don't know how they gonna do this. Okay, let the jury define. You know.
This is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence case should absolutely be suppressed.
And she said what she said.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Oops. Let's see what they say right here. I thought maybe the defense team would say something. hear. I want to hear what. I want to hear how the defense team gonna fire back. I want to hear what the I got to hear what they said. Defense had to say about this. Mm.
We'll get into the argument on that. So, with that, I understand the parties are proceed. The defense. Do you have witnesses to call this morning?
We do, Your Honor. We have two.
All right. Who's your first witness?
Corporal Brett Payne.
All right. Let's go with that. If Corporal Payne would step forward. You were sworn yesterday, as I recall, but we'll go ahead and do it again just for formality's sake.
Good morning. Could you please state your name and spell your last for the record?
Brett Payne, last is spelled Payne.
And what's your title?
I'm the detective corporal for Moscow Police Department.
Mm-mm.
Can you tell the court, I know you testified yesterday, but it was a different hearing, and so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
Been with Moscow Police Department for almost 7 years now. Prior to that, I was in the academic.
What is your role in this case?
I was assigned lead detective in this particular investigation.
Uh-oh.
So, as lead detective, can you explain from your perspective what that has meant that you have done?
Certainly. So it was my responsibility to basically view this investigation from 30,000 foot view, if you will, direct the teams that were assigned to various tasks, and then take in all that information, synthesize it, put it back out to our group, and then eventually consolidate it into an affidavit.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created. Would you explain that?
Absolutely. So the information was brought to us, various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day, and then as that information actually synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it? Warrants you worked on in this case?
No, ma'am. Several. I don't know the exact.
Several segments of different warrants, and some of this may seem choppy, but I'm going to try to give you and then Detective Mallory at once instead of bringing it back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right, and Judge, I have paper exhibits for you and for this, and so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am. I believe I had.
And so, given that, who did you rely on in creating the warrant?
Largely Special Agent Balance. He's the cast expert, so I relied heavily on his input.
At the time AT&T warrant 1 was secured, were you co-located with Special Agent Balance more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
So when you say mere feet away, were you guys in like a cubicle setting, or were you in offices with doors? What was this setting in terms of proximity to each other? Feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Were you aware of Special Agent Balance in his work in doing self AT&T records, having any access to AT&T records without a warrant?
I'm not aware of that.
Were you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
I'm surprised he took the
Exhibit 1, attached press AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on stickers. I think it's SS for state 1. I gotta get I should have started out by saying that the same stipulated. I can do that. You want me to do that per exhibit? I can get myself.
That's the lead detective, y'all, on the stand.
Detective Payne, can you look at page 5? On page 5, can you read what it says in the at the very end of the page in the sentence above wherefore that begins with the paragraph that begins in support? Can you read that paragraph?
In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of affidavits. The attached statement of Brett Payne, which is marked Exhibit A, and incorporated as the fully set forth herein.
And is that S1 the affidavit in support of the search warrant?
Yes, it is.
And that's the AT&T 1 search warrant that was the first one served on December 23rd, correct? And that language that you put in there, Exhibit A, is incorporated as the fully set forth herein. Is that the language you just read? Right. I'm now going to hand you State's Exhibit 2 to the AT&T first warrant. Can you review that first page, the first paragraph?
reviewed that, Detective Payne. Do you see that the language that I just referred to in the search warrant affidavit? Do you see that same language in this warrant, where you incorporate the affidavit, incorporate Exhibit A into your? See that language in S2, and is S2 the actual search warrant for AT&T? Can you turn to the last page on page 4? What time was the warrant served?
10:03 a.m.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct.
Would it help if I showed you the AT&T Mobility Propriety front page to verify? Judge, I'm not seeking the admission of this, just for purposes of him.
Look how the judge looking at him. The judge ain't on your team though. Judge on the prosecutor's team.
Judge, for the record, this has also been admitted already in Frank's D17, page 634. Detective, can you see on that came in at, I think it's 15:30? Thank you.
Bryan gonna outsmart all of them.
I'm now handing you Defense Exhibit A to the reply to AT&T suppression motion. No, it does not. That is attached to the reply as Exhibit A, AT&T, and that reply is. Can you see line 4 there? Oh, sorry, good. I would call it Exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says Exhibit A, AT&T.
This is the return of the warrant of S2.
Yes.
Let's call it S2. Or 2.1, pardon me.
That's fine.
That's associated with that. Contracts.
Judge ain't gonna let them win.
Detective Payne, on page 2 of that Exhibit A, it's actually just the front page where it says affidavit of Brett Payne. What does paragraph 4 say?
Paragraph 4 to line 4.
Line 2. Line 4.
As the warrant was served on 12/23/2022 by email fax.
So, do you know exactly what method was used?
I don't remember.
And it says warrant in that line, right? Does it say anything about the affidavit in support of search warrant accompanying the warrant? On the next page, receipt and inventory of warrant, do you see that? You look at description of property? What does that say?
It says 509-8458.
Can you explain how that's a description of property and what that means?
It just means essentially that with the information retrieved as a result of that phone number being queried.
And it indicates that that was produced how?
Interest was obtained by email.
And when that's received, did you do anything to verify that the data was within the date ranges of November 12th to November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that?
Oh.
Something with it.
Mm.
Was there anybody else that you relied on for that other than Special Agent Balance?
Not that memory brings to mind.
Let's now turn to the AT&T2 pen trap, and also known as pen trap and trace. Can you explain what a pen trap and trace is?
Pen register, best of my knowledge. Now, granted, as I've stated before, I'm not an expert in cell phone stuff, but best of my knowledge, register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or precision location data, rather. So it's essentially incoming and outgoing calls, what messages are received, and then part of that was where that phone was located.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pen trap and trace?
I don't think it was required.
So when the data was received on at 3:30, you gave that data was given to Special Agent Balance. Okay. And then what happened in between 3:30 and 4:53 when the second warrant was secured?
Talking technically speaking, or can I speak in generalities? That's all I really know.
Well, I want you to talk about what you know.
So the only thing I know is that the information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second trap and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning that was secured at 10:03, and then the second one was secured at 4:53 p.m. And you don't have a recollection of when you were working on those?
I don't remember.
You don't remember? Y'all gonna have to remember. Thank you.
All right. I think you have State's Exhibit 2 in front of you. Go back to that one. Can you see on page 1, what does it say that the time of that warrant was obtained?
Is what it says. Is that what you're referring to?
No, I'm referring to the one, the return, which should be in, I might be referring you to the wrong exhibit. And that was at 4:53. The second warrant was obtained at 4:53. I might not have had the pen drop.
No, you have that.
Look at the judge.
My understanding is, just so we're clear on, because I'm getting a little confused, is that we have the affidavit warrant, the warrant, and the return of the warrant all related to the first warrant to AT&T.
justice to today as we're going through testimony. My plan was not to go through every single warrant that we're arguing about and get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues I want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
One caveat words where you have this broad array of documentation that is presented. People will not scour the record to find support for motions that's not pointed out to the court specifically. That's well established with the case law items.
And Judge, that's why I am trying to grab the pieces and parts that I want you to be able to identify, and that's why I'm putting paper in front of you. So I'm hearing you when you've asked us to do that. All right, I'm handing you States Exhibit 1. And this is to the second AT&T warrant, also known as pen trap and trace.
One is also listed as one on the sticker. So that's going to cause some issues.
It's S1 attached to a different motion to suppress.
Well, hopefully we can grab
And what I think, Judge, are going back and working with your clerk.
not my concern. I know what all the documents are, what they relate to. My concern is reviewing the court's ability to understand what you're talking about today. That's my concern. So,
And do I need to go through and read and label all of these? And I thought that would create more confusion.
So she said what she was trying to tell you, Judge. She gave you the document paper, but she's trying to break down pieces out the document while you trying to be difficult with them. You're not supposed to be on nobody's side, but you are on the prosecution side. Well, we know that. Woo-wee.
The record, because these are all attached to specific motions with these labels.
this is marked S1, titled Affidavit for Search Warrant and Application for an Order or PIN Register or a Trap and Trace Device.
Yes.
The record will look at.
So, Detective Payne, is that the warrant that affidavit in support of the search warrant that you drafted for that second AT&T warrant? On page 11. At the bottom of the page, can you read that last sentence under probable cause?
In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of the applicant. See attached statement of Brett Payne, which is marked Exhibit A, incorporated as the fully set for the jury.
All right, I am now handing you S2, which is the search warrant and order authorizing installation and or use of pen register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772. Can you please turn to page 7? what time that was obtained?
Why don't Bryan just take the stand? They won't have to go through this. If he innocent, just take the stand.
I'm now handing you what is titled Return of Search Warrant, Exhibit A to Track and Trace. No, it is not.
Oh,
What do you call that, Judge?
excuse me, Minnie. I'm sorry.
On page, look at page 2. See the top, it's the affidavit of. Are you looking at Exhibit A, page 2?
Correct. I see what you mean. Affidavit of Lawrence Mallory.
Right, and then, but is that actually your affidavit? So that was a mistake. On page 2, the top of it says Affidavit of Lawrence Mallory. It's the affidavit of Corporal Payne.
I see what the judge saying. It's good to have the paperwork, but just go straight to it.
Now handing you Exhibit C, the reply to Track and Trace. Does not have
Excuse me, guys. Y'all, to me, let me stop. She giving them a lot of paperwork information that he already have knowledge of. But she need to get down to the business. I see what the judge talking about. All this paperwork, let's talk.
you look at, are you looking at that Exhibit C? Was cell site location data requested for this warrant on this page? And was requested? I'll refer you to the last paragraph where it says mark special instructions.
Come on, lady. All this.
Do you see any reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
Look at the judge.
Okay, the next warrant I want to talk about is Apple.
Bryan trying to tell them y'all should have hired me as the officer.
Prior to this case, had you
Oh,
No official training.
I muted, Keith.
and handing you as defendant's exhibit A, it does have a sticker, and it's to the Apple motion.
Uh, gonna give a shout out to everybody in the chat and everybody who watching. Yeah, this is the same case that we've been talking about for the longest. Okay, um, about Bryan Kohberger. We've been on this case for the longest. Now, what's going on today is, like I said from the beginning, that Bryan Kohberger defense team. The only thing they are trying to do is keep DNA evidence from being used in his case. It's a lot of things that a lot of evidence that they don't want to use, and they trying to get the judge to dismiss. So I just don't want to so anyway, so the defense team is trying to keep the DNA evidence from being used in his case. Okay, that was going on. It is just a continuation coming from um Thursday. Okay, you know, the day Friday. Okay. Um Brian, for those who new to the case, Bryan Kohberger is accused of murdering four University of Idaho students in November 2022. But the thing to this, y'all, is that to me, I don't even see I don't see too much of a probable cause. I don't. I'm trying to, I'm not on Brian's side, I'm just on the truth side. I just don't see it. And around 2 p.m. They had what they did, y'all. They opened up with a showcase in the courtroom with Bryan in attendance. Like I said, I was observing Bryan because I've been watching him for the longest, you know, since it's really happened. He don't lost a lot of weight. I know he's supposed to be vegan, but the thing is, when you locked up that vegan, I don't know what the vegan ain't like it is when he on the street. He don't lost a lot of weight. That's scary. Okay. That's what they doing now. They're arguing from both sides, and Judge put his little 2 cent in it. The defense argues that the collections and means of discovering the suspect in this case were unlawful, y'all. And she brought up words like secretive, policy, unconstitutional. Uh, that's how she first started. You know, started out that they hidden a lot from us, from the publics. They use tactics, drones, and she feel like some things that was unlawful that going on in this case. So I was saying that that's what I was saying. Uh, the evidence is the house. The house got plenty of DNA, not just a little dapper DNA from his dad. That's where the DNA came from. The little dap on the little sheet. Come on, y'all. Y'all know good well. Four people were murdered in that house, and all of that DNA was trapped in that house. When they were cleaning out that house, they was gonna burn all that stuff, and they tore that house down because that house is full of DNA just besides a sheet. Now, but it's gonna be up to the jury to decide that, y'all. That's who it's gonna be. But to me, I don't see what Bryan is guilty. I really don't. I just don't. And that genetic genealogist, I can tell y'all that machine, I don't know how in the world how do they use that, but that thing is true, y'all. If some you can go on there to see it show kin people some kin to you, that machine is the truth. It is real. Cause the situation happened, I'm gonna share this situation because it's real. So honey, it is real, it can be. Found out that I overheard a conversation, and I knew who. You know how you could find out if your cousin is your cousin. Down the line, who it is, and all that kind of stuff. So a situation came up to it. That's real. That stuff is real. Found out that everybody thought they was telling me something new about my nephew, but I already knew that my nephew before everybody told me that was my nephew. So that kind that genetic. When you go on there and try to find out who your cousin is, I don't know about some people now, but I know about that particular person. DNA genetic genealogist. They call it IgG method of discovering DNA evidence. But on Bryan Kohberger, they took allegedly. I bet they took some of Bryan when test Bryan Kohberger dad, and then got some of that DNA and allegedly put it on that sheet. Okay, it was left. But if that sheet would it was dropped dropped in and on the side of making medicine at Kaylee, it would have been filled of DNA. So I don't know how they got to that, y'all. Also, they brought up the databases such as GED match of the family tree DNA hosts the data with law enforcement having the ability to reference that data. And like she was saying, how you know this and how you know that. They want to know. So the DNA evidence is harder to match. DNA isn't on file, can make it difficulty to solve this case. But you don't have to have DNA. I guess you just have to have a probable cause. And I'm gonna tell y'all something gonna happen. That phone that they got is something about that Apple phone. That's why she asked them a lot of questions, and they don't have a lot of information about that Apple phone. I like them. So the defense, they continue to argue and everything. Uh, Something that the judge said. When the judge said about that Apple phone, see, he tried to correct something. He knew he let the cat out the bag, and then he knew that other detective were ready to go. I believe that they allegedly took him on the law took them on among themselves to cover up what really happened inside that house, allegedly, y'all. That's what I think. Allegedly. I really do. The state argued that Kohberger relative willingly unloaded their DNA to these data. I really don't think so. I really don't. I believe they made him do that. For somebody to be charged with 4 counts of murder for the death of Kaylee, Madison, Morgan, Ethan, and Zana in 2022. This is the time when we was covering over here Naziah case. We were trying to work on Naziah case during that time. And what the prosecutor is planning on doing with Kohberger, y'all, is seek the death penalty. His trial is supposed to start in August of 2025. So this is not a trial that you see went on the day that we covered. It was a hearing. I didn't finish it because I got kind of bored a little bit. I don't want to say bored, but I don't want to sit there and listen to all of that. The jury selection supposed to begin in July, y'all, July the 30th. So I will let y'all know when that starts, okay? That'll start. God, I wonder how they gonna select these jury, but because I know everybody heard, but everybody haven't heard about this case, so it may work out. I don't know, but that's supposed to start July the 30th of this year, and August 11, 2025. He's supposed to go to the court. So y'all be looking forward for that, okay? All right, y'all. I'm not gonna continue with this trial. Let me see. I just can't. Not trial out the hearing, y'all. Let me see. Can I skip it a little bit? Let me see. Let's see. Can I skip it? I'm gonna skip it almost to the end, okay? That's what I'm doing. Cause it really got my stomach growling over here. My stomach just making this noise. Hold on, y'all. Let me turn this music down. My stomach just growly. Sheesh. Hold on 1 second. I'm just gonna put it down to the end. Hold on, y'all. Just don't understand why is it still playing. I turned the music off. I'm gonna skip it all the way over to the end. Um, skip a little bit. It's kind of boring a little bit, y'all. Just showing up with fire and back. Let me skip
Or
it.
not page 6, I'm sorry. Number 6, line.
I skipped it,
Out a
y'all.
warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest. And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mallory, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody's supposedly has access to. Looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho killing case, which is 721 F sub 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho, but it really couldn't be more instructive in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research, among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the Apple account was first created.
Hmm.
Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those warrants. They knew that Bryan hadn't been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories, making the productions bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these detectives that have taken a huge role in this case who's evaluating what data and to what extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing some sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request for a preservation in December 21st, all the way until August, when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear, and to the extent that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants. As for the arrest and the car and the apartment, what I will close by saying on those, because it's not an issue of general warrant or a discussion of particularity, those are more reliant on the issues associated with ITG and Franks. And with that, I'd ask that you find that the warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
You want to respond to that, or do you want to have that's argued the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just address piecemeal this, and I can address just this. I can make this pretty simple for the court. You don't have to go down the rabbit trail that the defendant would like you to go down. The search warrant regarding the particularity requirement. And this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized
ain't even said nothing to be a prosecutor.
I was asked, are you the motion regarding the raid on my client's parents' home, search of his person here in Idaho, as well as in Pennsylvania, as well as in I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home.
Mm.
In the briefing, it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street in the usual channels in which that could have occurred. The point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging via the Franks motion. So that was the purpose of that argument. The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply. We set out a few different reasons why that should be the case. It doesn't seem like there's a big argument going on there, so unless the board has questions about it, I'll leave that alone. And then the other issue that I wanted to touch on is the right of privacy in the information that we have in our Amazon goings about why should the state have to have a warrant for that. I thought we set it up pretty well in the briefing, but I think the big concept and takeaway here is Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that, to a great extent, the United States has become a sort of panopticon. That is, the concept of panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the 70s, 60s. It stopped making sense once all its information is easily accessible the way that it is. So our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive. Otherwise, we're essentially allowing the executive to know everything about us all the time. So the state makes the point that, similar to the one that Professor Kerr made about Miller going and getting bank materials, once those were things that could be done simply and efficiently, make these records.
Yeah, in other words, only thing he's saying only thing the lady when the prosecutor stood up, she was just saying that the defense team have no reasonable rights to privacy for the DNA that's left at the scene. It left at the scene of the crime. But it's a lot of things that the defense team said really made sense to me. I also said that I'm with the defense team, and cause the prosecutor not saying nothing, and they keeping secrets. But the defense team also said that once Kohberger was identified as their possible suspect, the law enforcement officers either they purposely or recklessly lie or omitted crucial information when they asked the court to issue search warrants for his apartment, his parents' house, his car, his cell phone, and even more of his DNA. They want all of that evidence kept out of the trial as well. I don't see how they gonna keep all of that out though. Yeah. If they keep the house, if they keep the cell phone, if they keep the apartment, the parents' house, and they keep all of that out right there. The DNA is in the house, y'all. The house that they tore down is the DNA. That's the evidence right there. So I don't know how they gonna do this. How they gonna go about with the IgG evidence and that's genetics, genealogists uh, evidence. That's what they saying. They figured that I don't know how they gonna do this. I don't think the judge gonna go for that, y'all, because this a criminal case. Uh, and they keeping secrecies, secrets.
Have to go out and get the cash. The parties in this case, because of Amazon, Kohberger didn't have to go someplace to purchase items.
That's right.
All of that would have been out in public. He's doing it on his computer. So why should that be private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. We don't require a warrant. We essentially put all of ourselves at hazard being snooped on and into it.
Well, I got some bad news for y'all, for us, that we've been fighting this case too long. And why the judge did this, he said no one would be allowed into the courtroom, y'all. But that the open portion of the hearing would be live streamed from the court's YouTube page. They keeping us out, y'all. They don't keep us out the courtroom. And I don't understand how Christy and Steve go have gone have parents said that he deserved to be unalive, but they ain't got enough they ain't got enough probable cause to me. Regardless of your four victims, y'all ain't got enough evidence to me. And they keep saying there's evidence to show that she awakened and tried to get out of the situation, said she was trapped. But the thing is, y'all, in that bed, if he did what he did, evidence all in the house, y'all. The evidence is in the house. The evidence is in the bed. And you can't tell me ain't no DNA on that floor after doing what he did to them. Calm down. Calm down. Whew. Calm down. Y'all, this all I wanna let me see what the judge gonna say at the end. Let me skip it a little bit, y'all. Okay. Let's see what the judge gonna say. Oh, there you go. Hold on. Hold on. She came back up there. Let me hear what she got to say.
Court saying, I it sounds to me like lists don't do it. If you want to interpret a record, that's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are and I believe what they reviewed. So I recall off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing and stop because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
So that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just old cloth new. Experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly, I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I would assume we would deal with that then. It's when I read whatever we decide to use, that's very, very wrong. That's it. Thank you.
I think she nervous.
That's pretty short. I don't think that there's really much.
I always want to be short.
State's position, we've complied through our expert disclosures, criminal rule 16b7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert, and the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over disclose those opinions in caution rather than under disclose, because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you are going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial.
Okay.
Where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is.
Thank you, too.
And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste in a trial trying
That's
to find
right.
where to disclose that. And so I think sometimes, and I'm not saying we did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. It's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to, and give a disclosure of what they're going to testify to, what those opinions are, and to be looking at that as you're thinking about their testimony, as you should be doing, certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. And so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're The other thing, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but there's a caution. We're going to put it in an expert. But as a caution, it could be viewed that way. I suggest you treat it that way in terms of what you give. And that goes to both sides. I haven't read your disclosures yet, so I don't know where that stands, but certainly goes to both sides. And I know that also, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree. So I appreciate that.
I think the court will anticipate that there's a rather large filing that contain a lot of actual report. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts
Well,
would say.
and if they supplement, you certainly can supplement based upon what they supplemented. I permit that. That's
I do appreciate that. And should that become necessary, we'll definitely take up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the cast report. The court's heard a lot about the cast report. When I say cast report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture. And it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those. The court hasn't seen that. Their disclosure number, that's Mr. Cox. That's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60-some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowry, Tenzel, and Uric. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, be wondering if this particular thing was ever disclosed. I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Bryan has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us
She right.
what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out and in and out when we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far.
So I'm going to give both sides an example of what I expect. There's been talk in this case about DNA. If somebody's talking about DNA and they're going to let the jury understand what DNA is, and essentially going to do a mini course on DNA, I expect to see that in expert disclosures. Not that they're going to do a mini course on DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they're conveying that is expert in nature. And so it really does become both sides to spend the time to do that. That's the last I'll say about it.
All right, y'all. So that's it. That's it. That's it. Ooh, Lord, honey. Do y'all think that was unconstitutional? Do you think that's unconstitutional? Happening? I don't know what's going. Ooh, this is gonna be good. So, like I said earlier, that we're not gonna be able on the part of the trial. And I wonder why they doing it like that. I don't think that we should be blocked from seeing the trial. I really don't. I think that we should be able to see this trial because I've been waiting on this trial all these years, and then he wanna. He said the judge said that no one would be allowed into the courtroom, but that the open portion of the hearing would be live streamed. Man, that ain't nothing. I want to hear the whole thing. We've been here this long, so I don't understand why the public why we can't see it. Y'all tell me what y'all think. I appreciate y'all being here. Like, share, and subscribe to the video, y'all. I'm gone, y'all. I'm hungry. I really this did it for the day. I'm out, y'all.